Down. Good evening, everybody. Tonight is Monday night, the 16th of November. Tonight is the first section of part 2 of November's fall seminar. Tonight will go from 6 p.m. to 8 p.m. It is the first section of ethics, rules, and regulations. Tomorrow, we will complete the second 2 hours from 6 p.m. to 8 p.m., making a total of 4 credits, which would be a total of 8 credits for this seminar. As we've said before, this goes toward this current 24-month cycle, which will end in May of 2021. At which point you will need the 40 credits. So you still have many months. We will have another seminar in March of 2021 that will also be of 8 credits. So tonight's presentation will be done by Joe Dendler. Unfortunately, Dave will not be able to attend tonight's portion. And I'm going to hand this over to Joe in a couple of minutes. We have 61 home inspectors. If somebody out there can send me a chat message to make sure that the chat function is working, I would appreciate that. Just one person. That's all I need. Okay, we are working on the chat function. If anybody has a question for Joe, there are no hoagies tonight, by the way. Virtual hoagies, by the way. So if anybody has a question, please feel free to type it. If it's not related to tonight's subject, please go offline and send it through our info at Southern New Jersey ASHI. Please do not ask other questions on this chat. It is not the easiest thing to coordinate and keep online. So it is now 6:01. We have 69 attendees, and I'm switching the ball over to Joe. Thank you very much, Joe. And it is now your turn.
Thanks, Neil. I just need you to hit the share screen. There we go. Awesome. And there we go. Everybody should be able to see the slides now. I am Joe Dendler, as Neil said. I'm going to be substituting for Dave Goldstein tonight, who has a personal issue that he has to attend to, actually tonight and tomorrow night. But certainly thanks for giving me the opportunity to speak with you. I know Dave would rather be here, but I'll do the best I can to sit in for him. A little bit about my background real quick. For those of you who don't know me, I'm an attorney. I've been licensed to practice law for about 22 years now. For many years, and for much of that time, my entire practice was defending home inspectors in arbitrations and litigations for the various insurance carriers. Now, I am the Chief Officer for Claims and Risk Management for the Elite family of companies, including Elite MGA, Elite Re, which is our new captive wholly owned insurance company, and Inspector Claim Management, the third-party adjusting company we use to manage the claims. So in my capacity now, I see every claim that comes into our insurance company from everywhere in the country, and I manage all the attorneys that we hire to represent the inspectors and do all the risk management training and everything else for the companies. So it's a little bit different now what I do as opposed to what I used to do, but now I just see the claims from everywhere instead of just New Jersey and Pennsylvania. I'd read Dave and also bear with me, I am working with a slide deck that I didn't prepare, so there may be times like this where I flip through and find something I have nothing to say about, and certainly these are Dave's qualifications, And I definitely don't measure up to any of these, but I do know the law, and I do know claims related to home inspectors and what those claims entail. So if you want to reach Dave for whatever reason, here's Dave's contact information, and we'll show that tomorrow as well. So tonight we're going to talk a little bit about ethics. These are the really dry regulations that relate to how you can operate your business as a licensee in New Jersey, and that relates to your advertising, your marketing, your licensing, how you display your license number and the name of your company, where you're allowed to receive mail, and also relates to all the interactions you may have with various agents and clients and sellers and so forth. Now, in some of these situations, because there's been relatively recent changes to some of these provisions, and just as a little bit of background, these are the New Jersey Advisory Committee regulations for home inspectors. And the things that are in red on the slides should be the things that are new in these regulations since the last time Dave gave the ethics class. So anytime you see red here, those are changes that were recently made to these regulations. So for example, the first regulation, and this really relates again to your interactions with other people, home inspectors are prohibited from performing or offering to perform for an additional fee any repairs, and now they've added renovations, additions, or alterations to a structure on which the licensee or the licensee's company has prepared a home inspection report. It used to just be any repairs, and so we would usually, when I would speak about this topic or I would do it with Dave, we would get a lot of questions related to what constitutes repairs, because some things aren't really repairs. Some things are new to the property that weren't there before. And it was a gap in the regulations and how they're interpreted. So they added renovations, additions, or alterations. So that covers the entire universe now of things you might do for an additional fee on a structure which you've inspected. Now, what's different in New Jersey as opposed to a lot of other states or the association-based regulations are that in some instances, in some places, there's a time limit. So maybe you can't do any of this type of work on the property within a year of when you perform the inspection. Because the underlying premise here is they don't want there to be any reason for you to report something that might not be entirely accurate in order to make money with your side business. Or to do some repairs or renovations for somebody. It's not that you're going to rip those people off, but it's the idea that if you do have a financial interest in something that might be a defect that you'd report, there's the opportunity there for somebody, not you, but somebody who may not be as solid as a business person as you, to exaggerate conditions in order to get the work on the repair or renovation. And so that's what they're seeking to preclude here. They're taking that off the table so that there's no opportunity for you to be in a situation which might not pass the smell test. Secondly, the regulations prohibit you from inspecting for a fee any property in which your company has any financial interest or any interest in the transfer. Again, the basis for this is that your opinions would not be based on something other than your expertise and the exact observations you've made when inspecting that particular piece of property. So they don't want you to have any interest whatsoever in the transfer. What that means is if for some reason you're being paid based on whether the property sells or not, or whether the client buys it or not, that would be a situation where you have an interest in the transfer going forward. Obviously, you can't inspect for a fee a property that you're going to sell or your spouse is going to sell, or your significant other, really, because you may still have a financial interest there. And the reason they also add your company is so there's no confusion that it's not just the licensee, it's the company you operate and work for as well. That you can't do that if that company has any interest, because some people may have an LLC that they're buying and rehabbing property with, and we certainly wouldn't want them then producing a report for the buyer.
Joe?
Yes.
One question we've been asked is, how long after the home inspection can a company perform any work at that home?
If you're the licensee and you or your company perform the inspection, the answer is never, based on how this is written. So let's go back for a minute. You'll notice there's nothing in there about a time period in number 1 there on the slide. And that's because they don't intend to open this up for you after a period of time passes. You can't ever, based on the way this is written. I'll also apologize in advance because my dogs will sometimes bark while we're doing this, and I'll apologize. If I'd known earlier that I was going to be covering this, I certainly would have made alternative arrangements, but I hope it doesn't interfere too much with what we're doing. It is a prohibited practice for you to offer or deliver any compensation, inducement, or reward to the owner of the inspected property, the broker, the agent, or the client's representative for the referral of any business to the licensee or the licensee's company. It says any compensation, inducement, or reward. They didn't see fit to change any of these terms or provide any more guidance on that, but I think it's pretty clear what they mean, which is you should not be offering or delivering any compensation whatsoever to any of the people involved in this transaction where you're doing the inspection. Now, client's representative under these regulations is limited to the attorney for your client. So if it's a situation where you're working north of Trenton and attorneys are still involved in the transactions because south of there they aren't, in that situation, then you can't offer any compensation, inducement, or reward to one of the attorneys on the transaction either. Compensation can take many forms. Certainly money is one way someone can be compensated, but there could be gift cards, there could be raffle tickets, there could be prizes, anything you can think of that might induce somebody to send you work is something you're not allowed to do. Again, and I say this all the time, everybody in the world knows that most of the referrals come from agents. Why they restrict you so severely from working with them, I'm not entirely sure. But anything you can think of that might be of value could fall within this based on how it's written. And so you need to take care if you're doing anything marketing wise that involves any compensation or inducement or reward, understand that that's a prohibited practice. Now, we often get the question, what does that mean? And is there an amount specified? I know with a lot of brokers and agents regulations, there's a de minimis amount, what we call something that can be an amount of gift that won't trigger a violation of this. There's no such thing in the home inspection ethics regulations that we're going to review. So they mean any and everything. Now, does that mean you drop some pens off there with your company name and phone number on it? That's not, to me, what they're looking for here. What they're looking for here is more of a pay to play or some kind of reward system that puts something in the hands of the referral source, other than they're sending their clients to you because of your good work and reputation. So just keep in mind that I don't think they mean pens and pads and calendars here, but I do think they mean anything that might have some value, monetary value. You cannot offer or deliver any compensation, inducement, or reward to your client, the broker, or the agent on behalf of a person or business entity. What that means is something that's given that really is advertising or marketing for another company. If you're not giving it away for free, then obviously it's not a compensation, inducement, or reward. But you can't be the person providing something to them on behalf of someone else as a way to transfer value to that client or somebody else involved in the transaction where you're not really paying for it, but it gives that third party access to your client, because that's what they really want, is the ability to market services to them. Now, if it's something that they're getting, you're not giving them, or they're giving to you for free, and it doesn't have a monetary value, then I suppose it would be okay in this scenario. But this is what they mean, is they don't want you out there for third parties giving away coupons. So for example, if you had a roofer and the roofer says, why don't I give you a bunch of $20 coupons off of a free roof inspection by me that they can use after they buy the house? with the idea that now the roofing company might have a lead. That's something you're not allowed to do. Now, if it's not a compensation, inducement, or reward to the client or the broker or anybody else in the transaction, then certainly there could be a number of things that wouldn't fall into those definitions that you could do for somebody as a marketing advantage. But ultimately, if it has a financial value, you have to be wary that you might be triggering a violation of this section. And understand these violations are the type of things that can result in a pretty significant fine or a suspension. And these are the things that really, if you look at any ethics regulations across the country in any state that has inspector regulations, these things show up in every single set. You cannot accept an engagement to perform and inspect. Yes.
Sorry, two questions. I was waiting till you finished that one slide before I asked the question.
Sure.
First question is, when delivering cookies, bottles of scotch at a holiday party for a broker's office, is this acceptable? That's question one.
So I would say that if the scotch definitely has a value, and it could definitely be construed to be a reward, anything like that, wine, scotch, a gift basket, anything like that. Now, a box of cookies, I mean, yeah, I guess I could shoehorn that into these definitions, but I think if you think about the spirit of the regulation, I don't think anybody's worried about the box of cookies. What they're worried about is the $500 gift cards and the free entrance in a raffle for a trip. Certainly alcohol, depending on what it is, can have a pretty significant value. And I would say that would probably fall within compensation, inducement, or reward. But again, things like pens, some cookies, a box of donuts, I don't think anybody's really looking to enforce the regulations on those type of issues. The focus really here is on pay to play. And what was the second question, Neil?
Second question is, can a home inspector recommend methods of repair and or a contractor?
You can definitely refer a contractor as long as you don't get anything in return for that referral. There's nothing precluding you at all. If your client says, hey, I'm new to, for example, I just moved here from out of state. You're telling me that I need to have a plumber come in and look at my system. Can you make a referral to a plumber? Absolutely. And you can give them a specific person, as long as you're not getting anything back in return from the plumber. So yeah, you can always refer people. There's no prohibition against that. You just can't, it can't be your company or a company you have any financial interest in, and you can't have any financial interest in what, anything that goes on between your client and that particular contractor. But you can always refer them to it. As far as for repair methodology, the way the regulations read, and that's not something we're going to cover here in the ethics rules, but that is more something that would be covered in the laws and regulations classes. But generally speaking, you're not required to offer any method for repair. Some inspectors do. Some inspectors have a particular specialty or background in HVAC or electric or plumbing, and they're qualified to make those recommendations, but you're certainly not required to. And I would say to you, you can't make any recommendations for anything that would require a license that you don't have. So engineering is the one that comes to mind often with home inspection, because we often see defects in a house related to structure or foundation. But unless you have the adequate license, you shouldn't be offering any opinion on how that should be addressed.
Okay, I'm clicking off.
Okay. It is a prohibited practice for an inspector to accept an engagement to perform an inspection or prepare a home inspection report in which the employment itself or the fee payable for the inspection is contingent upon the conclusions. In other words, you're not allowed to accept an engagement where, for example, you are just pass or fail a house and the client doesn't have to pay you if they're not going to go through with it, or that the house turns out to be not something that they want, or that the results have to be a certain way. That shouldn't enter at all into anything you do related to your report. And again, the spirit of this is they want the report to be your objective observations and opinions based on your professional experience as a home inspector. and they don't want anything else to enter into what goes into that report. And so the best way to prevent that is to limit you from writing things or taking payment based on a contingency that you don't know exists yet or not. And that's why this is there. So if you have a situation where you have a client, let's say you had a flipper, and they have you do multiple inspections for them as the buyer before they rehab the property and then sell it, and they say to you, look, I'm only going to pay you on the ones that we buy, that's a violation of this regulation. So you would have to have some verifiable way to show that you were paid for each inspection, that the employment itself was not subject to your results. You could see there's easy ways to work around that. And certainly you might reduce the price for all of them so that the average is that if they buy half, they end up really paying for full price for 5 out of 10 inspections, and that would probably pass muster here. But ultimately, they don't want you being paid based on your findings. It is a prohibited practice for you to provide a copy of the home inspection report or disclose any information concerning the results of the inspection without the written approval of the client or the client's representative, except when you discover a health or safety condition that would not be readily detectable by the occupant or homeowner and which poses an imminent risk of injury. This one didn't get changed. I've always had a little bit of a problem that it imposes on the inspector to decide whether or not they think that the occupant of the property could readily detect the condition that is so significant that the home inspector has to go outside of this prohibition and tell somebody about it. I don't think that's fair to the inspector, you know, on a limited view of the property and a limited time period there. But there's really two parts to this one. The first part is that they don't want you disclosing the results of the inspection or any of the information to anyone else except your client, unless your client in writing authorizes you to do so. The way a lot of inspectors deal with this issue is to have a provision in the pre-inspection agreement that says, you know, that the client agrees that you will produce the report to their agent or their attorney. And that way you've got written approval. I often get questions from inspectors where they did an inspection for a client and the buyer's agent has the report, but that deal falls through. Buyer's agent has another potential buyer and wants to see if they can just use your report. The answer is no. You're not allowed to disclose that home inspection report or the information in it to that client. Can you go re-inspect the property? Yes. But you're not allowed to disclose information in a report prepared for a particular client to somebody else, unless they give you written authorization. Now, client's representative here again means the attorney. So you need to have the client's written approval or their attorney can give you written approval. Nobody else involved in the transaction can do that. Now, they give you a way around this in situations where you discover something that could be a significant risk of injury to somebody who is on the property. In that situation, they want you to disclose that condition, however necessary, in order to avoid the risk of harm. So unless there's a significant issue related to health or safety, and you need to let somebody know at the time of the inspection or have an agent get somebody on the phone, other than that, you have to have the written approval of your client or your client's attorney in order to release any information related to the inspection or the report. Now, that has nothing to do with you receiving a subpoena about a particular inspection, and this comes up a lot. There are a lot of claims that go on in court between buyers and sellers where they don't sue the home inspector. It may seem sometime like that's few and far between in New Jersey, but that is true. And there are many occasions where if you did an inspection on a property that's subject to litigation, you'll get a subpoena in the mail from one of the parties seeking a copy of your file, your report, the contract, and everything else. If you receive a subpoena, you're allowed to turn over the documents responsive to that subpoena. And if you need help, for example, if you were insured with our insurance company, Elite Re, because we own it, that question would come to me. And I would say to you, no, you can go ahead and produce it. And I would show you what documents you have to produce and not produce. Otherwise, you would need an attorney to let you know what's discoverable and what's not. And certainly there's plenty of attorneys in New Jersey, even if I'm not practicing there full time anymore. And so, but you are obligated to turn the information over in response to a subpoena. If you were called to testify as a witness at an arbitration or a court hearing and asked under oath questions about it, you would be required to disclose that information then. You are also able to always disclose that information to your insurance carrier or your attorney to the extent that they need that information to be able to properly represent your interests. But other than those events, you have to be careful about what you disclose and what you don't disclose and to who. And if you don't use your contract to specify that, anything can be a written authority. You can handwrite, I agree that I give inspector authority to issue the report to these people, and have your client sign off on it, and that's written authorization. So there's no magic to it. There's no magic form, but you have to have written authorization to disclose it unless it's in response to a subpoena or court action or something where you need to disclose this information to your attorney or your insurance carrier to help you with a claim.
Joe?
Yes.
You've answered this question, but a question that came in: can a report be delivered to an attorney clients with just a verbal okay from the client?
No. Well, you have to have written approval of the client or the client's representative, which is defined as the attorney. So my reading of that would indicate that if the client's attorney, who's that to be their attorney, you're allowed to produce it to them without written approval of the client. But anybody else, you would have to have either the attorney sign off or the client sign off. Okay. Moving on, and you'll notice a lot of these seem to be repetitive. These are the actual regulations themselves on the slide. So you can notice a theme about who pays you and who your duty is to, and your legal duty with regard to these regulations for 99% of them. Your duty is to your client. Your legal duty is to the client. That's the person who pays you, the person who has to sign your pre-inspection agreement. That's the party who you owe your contractual and legal duties to under these regulations for the most part. And so you'll see it gets repetitive about who can pay you and what interest they may have and so forth. And so following along with that theme, you're prohibited from accepting compensation, financial or otherwise, from more than one interested party for the same home inspection. What that means is that the way this is written, you cannot accept compensation. Let's say you were hired by the buyer to perform the inspection. You cannot accept any compensation from the seller or anything, financial or otherwise, it says, from the seller, for example, for the same home inspection. And the reason, again, is they want your duties focused entirely on your client. And that party is the party who signed your pre-inspection agreement and has a financial interest in the transaction. So other than that, they don't want anybody else paying you. Now, sometimes I used to have home inspection clients who would sometimes get paid by the realtor. If it's the realtor on behalf of their client, it's probably explainable and probably is okay, but it's best not to do that if you don't have to muddy the water. Because again, you're not accepting direct compensation from the agent. It's the agent's paying on behalf of the client. And that can be for a number of reasons. It could be the client's out of the country. It could, any of those situations where the realtor might have an escrow account that they pay out of for these things. That's different. But what they really don't want to happen here is have a party who you aren't under contract with paying you extra for the same home inspection. Because again, they don't want that appearance of what we call an appearance of impropriety, the appearance that something doesn't pass the smell test. And so they want to make sure that you're only getting your money from one party to the transaction. And you cannot accept or offer commissions or allowances, directly or indirectly, from other parties dealing with the client in connection with work for which the licensee is responsible. So what does that mean? Well, let's say you inspect the property for the buyer and you say, well, you need a roofing inspection. There's some issues here that a roofer might be able to look at and give you a better idea of what's going on. And you give, following up on a question we had earlier, you give a referral out and you accept something from that roofer for turning them on to the client. That would be accepting a commission or allowance directly or indirectly from that other party, the roofer, who's dealing with the client in connection with your work, because they didn't get to that roofer but for your home inspection. So that's what they mean, is they don't want third parties paying you, and they don't want you offering commissions or allowances from other parties. So again, go back to the example I gave of the coupon. You can't offer a coupon to somebody when their attraction to the client or their reason or relationship to the client is related to the work that you're required to do as a licensee. So really, again, what they're trying to prevent is anybody else putting money in your pocket besides your client. You're not permitted to accept any commissions from any other trade or profession for information concerning the condition of the property, which is the subject of the home inspection. Essentially, this is where they don't want you saying to the roofer or the plumber, hey, you know what, I just inspected a house on Main Street. They definitely have some problems there. You should drop something in their mailbox or hit them up, and you get paid for that. Or you provide information to a third party about the condition of the property, and that third party then interacts with the client based on that knowledge. You can't accept any commission for that concerning the condition of the property. It doesn't really say you can't disclose it here, except in the previous one that talks about you requiring written authorization to be able to release any information about the home inspection. This is just really more explicitly related to preventing an inspector from going out and giving the high sign to someone to go look at this property because they might be able to make a couple bucks or sell them a roof or a new HVAC or anything like that. And so they want to make sure there's no financial incentive where you might do that. So that's what they mean there. You cannot fail to promptly disclose to the client information about any business interest of you, which may affect the client in connection with the home inspection. The question that usually comes up to me in this situation is, my spouse is the agent and they want me to do the home inspection. Do I need to tell the client that my spouse is their agent and that I have an interest? Yes, you do, because you might have a business interest there in addition to your own interest as a home inspector that the deal goes through. So there's nothing precluding you from doing that here, unless you haven't disclosed it. Now you're not allowed to do an inspection on a property where you have a financial interest in the transaction either. So either one or two of those provisions would apply when you have a spouse involved in a transaction for whatever reason. But this is more toward, let's say, for example, you have a business interest with the seller, that you get a lot of work from the seller. And now you're representing the buyer in a transaction with that seller. You might need to disclose that interest there, depending on the nature of it, in order to give your client adequate information about, where you owe your loyalties. And then on the same token, they don't want you to allow an interest that you may have in any business to affect the quality of a home inspection. And again, it's more geared toward preventing a situation where you might say that some part of the house is defective when it probably isn't, but you're doing that in order to generate money for your side business. That's, again, really what they're trying to look at here. It is a prohibited practice to use a home inspection as a means to obtain work in another field, which is not an additional inspection service as defined by NJAC 13:40-15.2. And those are the classic ancillary services that include WDI, radon testing, although it's much expanded now. We have oil tank sweeps and asbestos testing and lead testing and water quality and air quality and mold, all those other ancillary services that you perform. But again, if you read this the way it's written, what they're really trying to do is make sure that you're not using a home inspection as a means to obtain work as, for example, a structural contractor or a plumber or an electrician. That doesn't preclude you from offering ancillary services that are industry standard and that people may want to buy. For example, this does not prevent you. Let's say you offer mold testing services, but when you make the contract for this particular inspection, you have no reason to anticipate that they need mold sampling services, and the client doesn't order that service when they make the original appointment. And you go in and perform the inspection and you see stains and you call the client's attention to that and you explain to them that, I do, as part of my work, offer mold testing services. Here's what it costs. In that situation, you're not using the home inspection as a means to obtain work in another field, because that's work that you are qualified to do, that you offer. It's a field that you offer that service to the public, and more importantly, it's again something that's sprung from what you saw there. So it's not you using the home inspection to create more business for you. This is a situation where you offer a service that your client very well may need, and it's not dependent on the home inspection. You cannot engage in the use of advertising which contains any statement, claim, or format which is false, fraudulent, misleading, or deceptive. What does that mean? Well, can you go out there and say, I'm the best home inspector in New Jersey? Well, depending on whose point of view you're talking about there, you might be able to say that. There's a difference between what we call puffery, which is basically, you boasting about your company, and misrepresentation. I'll give you an example. I've had situations where an inspector buys an inspection company that's an existing business, and they buy it, part and parcel, and they start running the business, and the website indicates that the inspector is a certified ASHI inspector. And it turns out that the new owner is not certified by ASHI, nor is anybody they employ, but the website still indicates that and is still being used. That would be a statement, claim, or format which is false, fraudulent, misleading, or deceptive for several reasons. And so in that regard, you would be in violation of these prohibited practices for misrepresentation. Now, in addition to the advertising creating a problem for you as a licensee, because remember, if you get brought up on any kind of consumer complaint or anything related to these prohibited practices, this isn't a client suing you in court. This goes before the Home Inspector Advisory Committee if they make the complaint there. And the advisory committee cannot award damages to the person complaining about you. They're not empowered to do that. What they can do is fine you and penalize you financially and suspend you or require you get additional training and so forth. But they can't award damages to somebody complaining that you misrepresented your credentials to them. But this could be evidence in a civil suit where there is a claim for false or fraudulent or misleading advertising. So in addition to having a license problem in a civil court, this would be per se violation likely of the New Jersey Consumer Fraud Act as well. And the reason that's so critical and such a big deal is because in addition to just regular damages, it allows the plaintiff to triple the amount of damages and collect their attorney's fees they incurred as a result of having to bring this claim for misrepresentation or fraud against you. So anything that relates to your advertising or marketing is a two-pronged problem, because on the one hand, the advisory committee can pull your license or penalize you and fine you. On the other hand, you could be sued in civil court and the plaintiff would get triple the amount of actual damages they have, plus get all their attorney's fees paid. For the most part in America, each side pays their own attorney's fees when they go to court. It's a rarity, and particularly in New Jersey, where one side is allowed to make a claim to recover all their attorney's fees as well. One of those instances is consumer fraud. And so that statute is very, very, very onerous in terms of how it relates to what you do and don't do. So you should be mindful of that it's not just a problem with the advisory committee. You may have a bigger problem with a civil court, and none of those damages, those triple damages or attorney's fees, there's not a home inspection policy insurance out there that's going to cover you for that. So that would be out of pocket, which obviously could be devastating to any normal business. I mean, I don't know many businesses that can take a $50,000 out of pocket hit these days and be okay with that. And so it's something to keep in mind that can be a critical issue and cause you significant problems. You cannot engage in advertising which promotes a professional service which is beyond your ability or authority to perform. Now, where we sometimes have that come up is situations where an inspector is advertising that they offer, well, mold sampling services. And it turns out that they don't actually do them, or they don't have the ability to do them. They subcontract those out to a third party. It's important then that your advertising indicates that you don't perform the service yourself, that you use third-party partners for that service. Or, for example, the easiest way is to compare it. Let's say you advertise your company as X and X Engineering Services, and you don't have a license as an engineer. That could be a situation where this could trigger a violation or an allegation that you violated this provision. And so we have to make sure in our advertising that if we're using third parties for particular services, when we advertise those services on our website or in our promotional materials, we need to make sure that we always indicate in those that we don't perform the services in-house, that we use our partners, business partners, to perform that service. Now, obviously, there's other issues there related to having a subcontractor perform services and what that means in terms of liability for you and so forth and so on. That's a topic for another class, but always keep in mind too that, if you're using independent contractors to perform some of the inspection related services, you should make sure you have a written contract with that subcontractor, and that in that contract, they've agreed to make you an additional insured on their insurance policy, and also to defend and indemnify you in the event of a claim. Because if you don't have that in there, then unfortunately you don't have a writing. Even if they have insurance, their insurance carrier doesn't have to defend you when you have a claim related to that particular subcontractor's work. And so that's my little aside on independent contractors, but you can see where that can create a problem. So it's important that we follow all the regulations related to that, to make sure that we don't have any violations on our advertising, because it's a really bad way to end up having to pay somebody a lot of money when you're not really responsible for what their underlying claim is. And so just keep in mind that in addition to the responsibilities here, you're also, or can be responsible in civil court if something happens that relates at all to your advertising or marketing. And I don't know which session we'll get to them, but I'm sure we're going to be talking about all the different ways your marketing and advertising materials are regulated under these provisions, in terms of even down to the size of the lettering on your vehicle. But understand that this can be something extremely serious in terms of a violation, because it creates a situation where you really have no way to insulate yourself from it with insurance or any other way. You cannot perform or represent that you can perform a professional service which is beyond your ability to, or authority to perform it. So, for example, engineering is another great example of this. I guess that's the closest one I can think of. But again, if you don't have the required license or authority to perform a service, you can't advertise that you do it. It's a relatively simple thing. And then they specify engineering and architectural services here, and expand on it a little bit to say you cannot perform or offer to perform engineering or architectural services unless appropriately qualified. So I know we have, many inspection licensees in New Jersey that also have an engineering license or architecture license in some respects, or, a specific type of contractor license. In those situations, as long as you have the authority, you can always advertise those services. That's not a problem at all. And that won't cause you any problems with these regulations. But if you don't have the license to do it, you can't ever advertise that you can offer it. And particularly with engineering and architectural services, because you can see that, somebody who has a particular concern about structure beyond what the normal residential home inspector can offer, they may be searching out for people that advertise that they can perform engineering services. And so they just want to make sure here that as a home inspection licensee, unless you have these licenses, you're not trying to perform that service. And when the statutes they cite in here are just the statutes related to the licensing of engineers and architects. It is a prohibited practice to fail to inspect the systems and components required by the standards that's set forth in NJAC 13:40-15.16 without, and it used to say the written consent of the client. Now it says a documented reasoning for the licensee explaining the exclusion of a system and or component from an inspection. What they've really done is added a step to the process, because before, in your agreement, for example, you might have a situation where a client hires you and says, listen, I want to hire you to do the inspection, but you can skip the bathrooms. We're going to gut those as soon as we buy the place. So we don't really care what's going on there. We're going to put a whole new system in. Everything will be good. And then the client would have to, have something in writing saying that to you. So you could put it right in the agreement that the following systems and components are excluded at the request of the client. Now you have to provide a reason why you're excluding that system or component. So it can't just be the client's written consent. You have to actually have a reason why you can't do it. So, for example, you may have a situation where you get to a house and you cannot access the attic for whatever reason. The entrance is too small. In the standards of practice, we have the particular measurements for the access hatch and so forth, and what constitutes something being accessible and not. So you would apply that here. Let's say you get to the house and the attic is inaccessible. You would have to explain to the client, document it, which means in writing, the reason why you excluded that system and or component or that room or section of the house from an inspection. You can do that in the report. And really, quite honestly, you're already doing it, because the standards of practice say that in our report, we have to identify the systems and components that the regulations require us to inspect, and tell the client if there's something there we would normally inspect and we don't, the reason why we didn't. And so, besides the roofing requirements that do provide that you have multiple ways you can inspect the roof as long as you advise the client how you're doing it, it's kind of the same situation here. If you come across something you can't enter or access, you tell the client why you didn't inspect it. And obviously, you also tell them it would be a really good idea for them to have that inspected prior to closing, because we never want to forget that, unfortunately, we really do have to spoon feed people with some of these issues. And that in particular, telling them that they need to have that particular system or component or room or area accessed prior to closing is an important recommendation from the inspector. But before this just said you could get written consent. Now you have to document the reason why you didn't inspect a particular system or component. And, again, the reason this was usually a problem was because it makes a prohibited practice of what's really a civil negligence case, right? The inspector failed to properly inspect the heater, or based on the condition, I don't think they inspected it at all. Well, we see that allegation all the time in civil suits. And then we had this provision in the prohibited practices saying, any failure by you to inspect things that you're supposed to inspect now becomes a license violation as well. And so they gave you an out here to say that, you know, if you can document a reason why you didn't, then you don't have to have the written consent of the client, but you do have to document it in the report. So just keep in mind that, you know, in addition, again, to having potential civil liability with regard to an issue involving the inspection, that if it also touches on one of these prohibited practices, it can cause you a problem with the licensing board. You cannot employ any person as a home inspector who is not licensed as a home inspector. What it does is this puts the onus on the licensee owner of the business. And, you know, not every home inspection business is owned 100% by a licensee, but let's say that, you know, you are the person who owns the company as well as being a licensee personally as a home inspector. You have to verify that the people you hire have the appropriate licensure and qualifications. Now, you know, thankfully, New Jersey, if you go on the Department of Consumer Affairs website, you can check people's licenses and the status, and particularly with home inspection. So you can put a name in there and it'll tell you if the license is active or not. And if the inspector has a history of some complaints to the committee, at least it was for a few years ago. I haven't looked in a while, but I think you can actually see that information on there as well. So it's incumbent upon you, the business owner, to make sure the people you're hiring have the qualifications that they say they have. And go back to my other example of, you know, you advertise something on your website as being a certified ASHI inspector, and you're not. Well, that goes for all your employees as well. You know, so if you advertise, we only use ASHI certified inspectors, and it turns out that 2 of your inspectors aren't certified, that's a misrepresentation as to the qualifications or the quality of the service. And so that can create a problem and create a claim. And so it's incumbent upon you to make sure that you verify that these people are who they say they are. And you can then, of course, be in violation by employing somebody who doesn't have a license. Not only are they in trouble, but now they've added a claim, a consumer complaint against you as well, for having somebody in your employ who isn't licensed. And I can tell you also from, you know, the litigation side of things, that can really cause a lot of problems in a lawsuit. If it comes out that the person you had doing the work or you yourself didn't have the qualifications you said you have, because even if you really weren't negligent or really didn't make any mistakes, you can imagine, you know, the average juror sitting in the jury box and hearing that you misrepresented who you were or the quality of your experience or your work. It's not going to be hard for them to make the leap that the plaintiff's telling the truth, that you actually made a mistake during the inspection as well. So again, these things can play out in a lot of different ways. And obviously the quickest one is the advisory committee suspending you or fining you. You cannot practice as a home inspector without a license, with a suspended license or during inactive status. Pretty self-explanatory. If you're in a period of suspension for whatever reason, you're not supposed to be out there doing home inspections during that time period. Now, I've had occasions with clients in the past who were cited for this and they didn't actually know that their license had been suspended. The onus really is on you as the licensee to make sure you get that communication. And as long as they can show that they sent you written notice, it's going to be really hard for you to say you didn't have knowledge that you were suspended on a particular date. And so once that happens, you know, while the incentive might be to go ahead and do inspections because, you know, let's face it, the advisory committee doesn't have people riding around in cars looking for inspectors violating a suspension order. But, you know, it could be that one inspection that something else happens, something gets broken and a claim's made, and somebody finds out that you weren't licensed, then they you know, then complain to the board about it, you're going to get caught. So there's really no good excuse for working while you're suspended or if you don't have a license at all or you're on inactive status for whatever reason. And that includes any practice that could be defined as being a home inspector during that period. You cannot perform any act or omission involving dishonesty, fraud, or misrepresentation with the intent to benefit a licensee or other person, or with the intent to substantially injure another person. This is kind of like the advertising and marketing, but now it's broader, right? Now we're talking about not just, you know, your qualifications or representations about what you see, but that you're actually being dishonest about something or committing fraud knowingly, with the intent to benefit a licensee or other person, or with the intent to substantially injure another person. And again, I can assure you, if this is an element of a civil case, you don't have insurance for it. But basically what they're saying is if you misrepresent somebody or substantially injure another person, that's going to be a violation of this code as well. And this type of clause appears universally in nearly every professional ethics set of regulations for every profession you can think of. There's always a dishonesty, fraud, or misrepresentation clause that enables the licensing authority to pull your license for reasons related to consumer fraud. And you cannot perform any act or omission involving dishonesty, fraud, or misrepresentation in the performance of a home inspection or preparation of the report. That more relates to, you know, the performance in the actual written document as opposed to general acts of dishonesty. But again, any kind of intentional act where you seek to either benefit yourself or help someone else benefit in a transaction, you can be found liable for it, and again, be in violation of this regulation. It is a prohibited practice for the home inspector to do any of the following: pay or accept a finder's fee or referral fee to any person in connection with a home inspection. That "or accept" was recently added. It used to be the onus was just on you. The way this was written, it said that you can't pay a finder's fee or referral fee to anyone in connection with the home inspection. But now they've added "or accept." And how does that change things? Well, what that means is that you cannot accept any kind of a fee from a third party in connection with your home inspection. So if a company says to you, we're going to pay you $5 for every lead you give us on your home inspection clients, you know, alarm companies used to do it more often than not, but you can think any profession or any business related to the actual residential building, you can see where they would have an interest in having information. So you're not allowed to accept a fee from anybody else in connection with that home inspection. So if somebody says, I'll give you $5 a lead for alarm leads, you're not allowed to do that. You're not allowed to accept any kind of a fee. Now, they were specific here and said finder's fee or referral fee. So it doesn't say, you know, directly or indirectly, or doesn't say any compensation, inducement, or reward. This is a little more specific. But that's what they're trying to prevent. They don't want anybody else to be able to pay you money for any information or any kind of leads related to your home inspection. And so, you know, now that this is in place, the argument would be from the board that it's abundantly clear now that you can't accept a fee. Before, it was just clear that you couldn't pay somebody to get referrals. Now you can't accept a fee from some third party in connection with your home inspection. And then the final one is really a catch-all provision. It's fail or refuse without good cause to exercise diligence in preparing a home inspection report, delivering a report to the client, or responding to an inquiry from the client. We do get these from time to time where a client is calling the inspector to ask questions about the report after the fact, and the inspector is not responsive, and then the client goes and makes a complaint to the advisory committee. That does happen. And so you are required to respond to reasonable inquiries. I would say to you that if it becomes a situation where you have somebody calling your office and screaming at you, that you're not obligated to engage with that lunatic. But you are at least supposed to, you know, in reasonable circumstances, respond to clients' inquiries promptly. Obviously, we have a duty to deliver the report to the client in a prompt manner. I have had several cases where, you know, the client hires the inspector and says, you know, I really need this report by Tuesday. And Tuesday passes, the inspector didn't produce the report. The client's locked into the deal now and ends up finding a defect that would have been in your report and sues you. We have had that case. from time to time, although they're few and far between. And again, failing to, without good cause, to exercise diligence in preparing the report could be really negligence. And that touches again on a civil action, but now they've basically taken what would usually be a civil action and found a way that they can enact some justice on you if they think you violated this provision. And then engaging in any of these prohibited practices shall be considered professional or occupational misconduct within the meaning of NJSA 45:1-21 and may subject the licensee to the disciplinary provisions of 13:40-15.20, and that's the provision that gives the advisory committee the authority to fine or suspend you for particular things. So that's the prohibited practices section that Dave had queued up for you. Before we move into the rest of this, I want to make sure with Neil that we are supposed to move into the rest of this. And also, if we have any questions about the ethics and the prohibited practices, it would be good probably to hit those now.
We can't go into it. It is now 6:59, so it's up to you when you want to take a break. This seems to be a great time to take a 10-minute break.
Yeah, it definitely is, Neil. I wasn't sure how you guys were doing that. So we'll take a 10-minute break and then come back and start this next section.
Absolutely. There are no questions. The only question, the last question that came in, and I was waiting for clarification. Can you give a few examples of a good cause? But Mark, if you can clarify, and we'll ask Joe when he returns after the break.
Sounds good.
Okay.
All right, thanks. We'll be back in 10.
You got it. So we'll be back at 10 minutes after 7 to complete the next portion of this 2-hour. We do thank everybody. Please do not leave. This is not over. This is just the first portion of this Monday night's 2-hour seminar. So again, we do thank everybody for attending, and keep the questions going, and we will answer those questions, we hope properly. Have a good one. We'll catch you in 10 minutes. Welcome back to the second hour of the Monday night, trying to make a bad joke, but the second hour of the webinar from Southern New Jersey ASHI. Joe will be going into law and regulations. A couple of questions that did come across were about the certs for the seminars that we've had during this month of November. Those will be put together upon the completion of all the credits for the November seminar, and then emailed out to the individual home inspectors that have been on and have paid for these seminars. Second would be a plug to both Dave and to Joe. Both have worked together. And if I could do this plug, Joe?
Of course.
Both Dave and Joe have worked together and put together updated agreements, agreements for most of the services that all of us do, whether it be just the home inspection agreement, radon, termite, etc. For more information on this, contact Dave. He can give you the information you should need. I'm not trying to leave you out of the loop, Joe, but I figured it's better to Dave. And these are great agreements that you probably would like. And if you have not updated your agreement, if you're using an old agreement, this may be the time to consider purchasing and looking over these agreements. And on that note, I throw the mic back over to Joe for the second hour.
Thanks, Neil. And just following up on that, if always check with Dave, because I really am not involved in the day-to-day management of the inspection contracts business anymore, but I know Dave runs specials from time to time and certain combinations of stuff for the ASHI group. So you should definitely check with him in terms of seeing if there's any specials. Mostly for New Jersey, if you go on inspectioncontracts.com, most everything I think that's available is still up there. But like I said, check with Dave, because he may be running specials for your group that would knock the price down, or he may have a discount code he's using right now. So definitely check in with him. We're going to move on to the laws and regulations. Now this is the more nuts and bolts of how you do your everyday job versus focusing on how you deal with, you know, your particular relationships with other parties to the transaction. So in terms of this is more of the stuff that if we do see, you know, when I used to have people have complaints before the advisory committee, a lot of them would relate to the stuff we're going to talk about now, and I assume tomorrow. So some of the definitions that are in the advisory committee regulations are critical for being able to understand everything else we're going to talk about. And accessible is one that comes up all the time. And because that really, you know, is the first line of whether or not it's going to be something that fits within your scope of work is it accessible to you? Because as you know, we disclaim anything that's not visible or accessible. Now it means available for visual inspection without requiring the moving of personal property, dismantling, destructive measures, or any action which will likely involve risk to persons or property. And so you don't have to take any heroic efforts or break something to find everything. If you would need to do that, then it's not accessible to you. And if it's not accessible to you, then it's not something that has to go in your report. So just keep that in mind, that you know, it's furtherance really for the public of explaining the visual nature of an inspection and what you can do and can't do, because more often than not, unless you're doing a pre-listing inspection, your client doesn't own the property. And so you can't go around breaking things that belong to somebody else to perform an inspection. Now, again, just as a refresher, any place where there's red typing or strike through lines there, what's the stuff that has the line through it is what used to be there. And the stuff without the line through it is how it reads now. So they did change the definition of additional inspection services. You remember we talked about those earlier when we said, other than the typical additional inspection services outlined in this chapter, you're not supposed to be able to advertise or offer that service without a particular license. And so here they've refined the definition of additional inspection services to mean tests performed by a licensee that are not part of a home inspection, but which, in the opinion of the licensee, are warranted or which the client requests. They may include, but not limited to, and then radon testing, asbestos, lead paint, carbon monoxide, urea formaldehyde testing. Such testing may be performed providing the licensee has the relevant experience. So really, they didn't change a whole lot else other than swapping out home inspector for licensee. So that's really more of a clerical fix there. But the gist of this is that the usual things that people offer, they're all okay, but anything above and beyond that isn't really an additional inspection service and may fall into a different profession for which you would be required to have a separate license. And additional inspection services also means inspecting systems and components that you are not required to inspect, but is prohibited from inspecting. I think Dave's got a typo in that, but it's that you're not prohibited from inspecting. So I review that with him before tomorrow night. But essentially, what they're saying here is all the usual types of ancillary services are fine and do fit within the definition of additional inspection services.
Joe?
Yes.
Question for me. The last comment, the last screen you had.
Yeah.
You mentioned the word, the A word, asbestos, lead paint, even
Yeah.
though it may be in the regs. Now putting your hat on, putting a different hat on, insurance wise, can a home inspector test for asbestos?
Well, yeah. So I can give you an example. I can only talk about, I used to talk about everybody's programs, but now I have a new one, which is the one that I developed actually. So this insurance company we have, Elite Re, we built that from ground up, and the entire purpose of it is to insure home inspectors, and so that we didn't have to answer to the Hanovers and Hartfords and AIGs of the world when we kind of knew what was best. And they really got in the way of us being able to help inspectors. And so one of the things we can do now is, we offer coverage for asbestos testing. The test is, if there's a license that's required, then we check to make sure you have the license. But that's an ancillary service that can be tagged on to our insurance policy, certainly. Now, there's a nuance there, because I know there's a lot of programs out there that, a lot of times asbestos is really the subject of frivolous litigation, right? Is that somebody just claims that the inspector should have found asbestos and didn't, because in the normal course, an inspector doesn't inspect for asbestos. That's specifically excluded as a hazmat under the exclusions that we're going to talk about here, probably more tomorrow night. So a lot of times we get suits against our insureds where that's the claim. Now, there's a lot of companies out there that say, well, unless you have the insurance endorsement to do that work, we're not going to cover you, even if somebody is alleging you should have done something you weren't required to do in the first place. We take a different approach. We will defend our insureds always in those claims. If you're providing asbestos services and didn't ask for the coverage, that's a different animal to me than somebody accuses you of missing asbestos and you never agreed to perform that service in the first place. But under our policy, we do offer an endorsement for asbestos and tens of other different ancillary services, and you would still be covered under your E&O policy for a claim related to that. So it really depends on your company. I know our company does offer that coverage.
Thank you.
Yep. I think we got everything out of that slide. We can. Client. This definition is critical. If you remember in the first hour, I talked a lot about who you owe your legal and contractual duty to, and that's the client. And this definition triggers all the responsibilities that you have related to that client. And it's any current or prospective homeowner. So it's either the buyer or the seller who engages or seeks to engage you for the purpose of obtaining an inspection of and written report regarding the condition of a residential building. So they've narrowed, the Licensing Act had a much broader definition of client, but when the advisory committee updated and created their own regulations, they narrowed that definition. So the client can only be the current or prospective homeowner. That's it. Nobody else can be your client for purposes of this statute. And again, as you'll see, we'll get into here, is that there's a lot of things that are triggered based on who your client is. And so you need to keep in mind that unless it's the buyer or the seller, they can't fit the legal definition of a client. Now, a corporation can be a buyer or a seller. So it doesn't prevent companies from owning residential real estate. But your client can only be the current or prospective homeowner. It's not the parents of the buyer. It's not the seller's handy person. It's got to be the actual buyer or seller. And again, it presupposes here that when you do an inspection, there has to be a written report attached to it. That you can't do inspections without a writing. That report doesn't have to be even more than a page, but there has to be a writing with regard to to make it a home inspection, because under here they define client as including somebody who has to receive a report. And again, these changes in red, the only thing they did is swapped out home inspector for licensee to make it uniform with the rest of the provisions, but it's the same difference for your purposes. The client's representative is an attorney, and that's it. And it's important to keep in mind here the last sentence here. For the purposes of this subchapter, a real estate broker or agent is not the client's representative. Now, why is that important? Well, on the one hand, it's important because there's certain things the client's representative can do on behalf of the client. Sign the inspection agreement is an example of that. The broker or agent can't do any of that. Only the lawyer can do that. And only the lawyer, as we talked about in the first hour, can give you written authorization to disclose the findings to another party. So client's representative in this instance will only ever be your client's attorney with regard to that transaction. To describe something means to report in writing a system or component by its type or other observed significant characteristics to distinguish it from other systems or components. What they mean there is you have to, in describing it, you have to be able to explain to your client the difference between this and other systems or components in the house. And again, it's understand that most of your clients have a very remedial, if any, understanding of how a home works or how everything's interconnected or what the differences are with these systems and components. And so what they're striving for here is requiring you to describe things so that you differentiate it from other systems or components in the property. Direct supervision. This relates to trainees, and the definition, again, was just modified from licensed home inspector to licensee, is physically present at and monitors the entire home inspection and prepares and signs the home inspection report. So when they say in the statute that a trainee has to work under direct supervision, what they mean is that you're actually at the inspection, you watch the inspection, and you prepare the report, not the trainee. This is the working definition for home inspection. It did change somewhat. The original Licensing Act was a little bit different, but it's not very different. The definition of a home inspection, again, is a visual, functional, non-invasive inspection. These terms are all there to protect you because these are all the things you can't do when your client doesn't own the property, and that's in large part the types of inspections you're going to do. Conducted for a fee or any other consideration. There has to be consideration. Does it have to be money? No, it doesn't, but there has to be some consideration exchanged to make it a binding agreement, and performed without, again, moving personal property, furniture, equipment, etc. All that's there to educate the public as to what the limits are on what you're going to do and not do as part of the home inspection, so that the public is aware and so that the courts are aware. If we have a lawsuit involving a home inspector, the jury or the judge, depending on who's deciding the case, is going to use these definitions as part of what somebody in the case has to prove or disprove. This is what a jury is going to know about what a home inspection is if there's a jury trial in New Jersey related to a home inspection. And so it's also important that it illustrate to the public all the various limitations on your scope of work. And of course, it lists all the required systems and components that have to be inspected, and then excludes recreational facilities and outbuildings other than garages or carports. So if there's a cottage, that's not to say you can inspect it. You certainly can, but it means that you're not required to. And any recreational facilities, you know, the kids' treehouse in the backyard, the tennis court, the basketball court, the pool, all that stuff is excluded. Now, you can inspect those things for a separate fee, or if you specialize in pools and you can do pool inspections, you know, that's certainly permissible. But what they're really saying here is you're not required to do any of that stuff. Definition of a residential building is a structure consisting of 1 to 4 family dwelling units. The reason this is important is because all these regulations only speak to residential home inspections. They don't at all speak to commercial inspections. So if you're doing a structure that's more than 4 family dwelling units, that's not subject to these home inspection regulations. That's a commercial inspection. And New Jersey doesn't have regulations yet pertaining to commercial inspections. So you would use standards that are available in the industry, the ASTM standards. I know Dave and I used to use in our commercial inspection agreements. That's a standard of practice that you can cite to and adhere to and use as a limitation. But essentially all these regulations that we're talking about only relate to an inspection of a residential building. And that's all the advisory committee has authority to regulate. So other than that, it would fall outside of the scope of this act. Material defect is a critical definition. It's a condition or functional aspect of a structural component or a system that is readily ascertainable and that substantially affects the value, habitability, or safety of the dwelling, but does not include decorative, stylistic, cosmetic, or aesthetic aspects of the system, structure, or component. What they mean there is that it has to substantially affect value, habitability, or safety. Now, it's a little inartfully written, but you know that's the crux of it. The real problem with this definition is the word substantially, because that's not defined by these regulations or really anywhere else in the law in New Jersey as it relates to home inspectors. And so when it's left open like that, it's left to the party deciding a case, for example, as to what substantially affects value, habitability, or safety. That can mean a jury. So if you think about all the people you know who can't get out of jury duty and get picked for a civil jury in New Jersey in a case involving a home inspection, that's the person that gets to decide if the thing you allegedly missed substantially affected the value, safety, or habitability of the dwelling. It's not based on an expert opinion, although that may be offered. But that's the real problem with the definition of material defect, is who gets to decide what substantially affects value, safety, or habitability. Now, value is relatively easy because value can be based on the amount it would take to repair a condition that wasn't reported. So we can tell what a substantial value issue is. If it's a $500,000 house and there's a $50,000 structural problem, that's 10% of value. I would say anybody is going to say that substantially affects value. But if it's a $500 problem on the same house, well, that's not substantially affecting the value of the house. But that simple $500 condition may significantly and substantially affect the habitability or safety of the dwelling, because there's a lot of things that are simple safety fixes and easy, like adding a railing or something that's relatively simple to do, but that can substantially affect safety of somebody on the premises. So values easily, habitability and safety are a little bit harder to define. But again, it's the average person that gets to decide what substantially means in that equation. Unsafe means a condition of a readily accessible installed component or system caused by obsolescence, damage, deterioration, improper installation, or inherent defects, which presents a significant risk of injury or property damage under normal day-to-day operation. And again, we have this word significant, which isn't defined in any of these regulations, and as such, It's up to a jury or a judge or an arbitrator to decide if something was a significant risk of injury. But that's what we mean when we say unsafe. So when they talk about your requirements to report something that is substantially affects the safety, they're using this definition. If it meets this definition, it's probably a material defect, regardless of the value of the repair. Some of these skip around a little bit. Dave does them in order, and I know, wanted to make sure I covered particular things that had changed for one reason or another. This is another one that changed since the last revision, that it used to be that you just had to pass the home inspector examination. Now it's the National Home Inspector Examination administered by the Examination Board. So it's the national test that you have to pass, and New Jersey just adopted that. But again, that's only a slight change.
Joe?
Yes.
Okay, one question, which is backtracking. It's come up a couple of times that a couple of guys would like a further definition, such as if a home inspector performs such tasks as an oil tank sweep and or scoping of a drain pipe, but do not have a special rider for those, but are assuming that they're protected under their home inspector insurance. Can you clarify and explain that to them?
Yeah, sure. So oil tank sweeps or any other ancillary service is generally not covered by your basic errors and omissions insurance policy unless you have a rider for all those ancillary services. So like when we issue a policy, we inquire from our insured what services you do. And then depending on the services you do, we add those into the policy. So if you're performing that service and you're out there doing tank sweeps for a fee or as part of your inspection, because that's not with a normal inspection protocol, yet your insurance has to specifically cover you for that. Now, our policy, if our clients tell us they do oil tank sweeps or you're going to get into it next month or whatever the case may be, we factor that into your policy and provide you with coverage for it under the E&O policy. But again, you have to look at your own personal policy. I can't speak to other companies' policies out there, but ours do have a particular endorsement that covers, man, I want to say at least 15 or 20 different ancillary services, from WDI all the way through. Now, the services you're talking about there, Neil, like oil tank sweep, for example, is not a regulated service in New Jersey. So we wouldn't check to see if you have a license for it or anything like that. We may ask if you have training, or we may ask what equipment you're using to perform the work. Those are the kinds of things we might want to know, but we would cover it as long as our insured, tells us they do that work. We would make sure it was in their policy. Now, there's a difference though. Oil tank sweep's a bad example for what I'm going to talk about now, but asbestos and mold and things are something you can mention. If if we have a situation again where our insured doesn't have the endorsement for asbestos because they don't do the work and they didn't offer that service, and somebody sues them and said, you were supposed to tell me there was asbestos here, we will defend that insured even if they don't have the endorsement, because that's a different animal. That's where they're being accused of something they believe should have been done, but the inspector had no duty to do it. That's different than the inspector actually performs the service and there's a claim related to the service. So that I need to be clear, because I know a lot of companies out there won't cover the inspector. And that was really one of the reasons why we started our own company, because we got fed up with, the big insurance companies saying, we're not going to cover this because, it's a hazardous material. Well, they didn't agree to perform that service. How can we penalize them and not defend them? It's just a frivolous lawsuit. So we ended all that with our company. But if you actually are performing the service, then we need you to tell us, and we will put it on your endorsement. I can't tell you off the top of my head what fees are for those, because I don't get into the nuts and bolts of the sales, but I can certainly tell you what's covered and how we handle it from a coverage perspective, because with our company, I make all the decisions related to coverage for every single claim. So I know how we handle that part of it. Was that the only one, Neil?
I put in two questions into one question.
Oh, I'm sorry. Did I answer them both?
You answered both of them. The
Okay.
OR scan was one and the scope was another, so I combined them and gave you one
Right.
question.
Yeah, and the sewer scope is the same thing. If you perform the service, then you need to have the endorsement. And again, it's just simply a matter of telling us. If you don't provide the service and somebody sues you and says, you missed a blockage in my sewer line, we would provide you a defense because it's just a frivolous claim, because unless you're actually agreeing to perform that service, you have absolutely no responsibility for what's inside that pipe.
I will ask you another question before you get onto this. And that question is that if you were informed of a claim in 2019 and it was early in your insurance and you kind of forgot about it and nothing happened during that course of coverage. And now you're entering your new policy of 2020 and you're in 2020 and you get served for something that happened in 2019. And your insurance company finds out that there was communication between the seller and yourself, and you forgot to notify your the insurance company of a potential lawsuit. And when you renewed your insurance, you indicated that there was no that you were unaware of any potential litigation. I throw the ball in your court.
Well, yeah, it's a big topic for us. So broadly, your errors and omissions insurance policy, not your general liability policy. The E&O policy is the policy that provides you with coverage when someone sues you for negligence or breach of contract related to your inspection services. And if you have an accident during the inspection, like you leave the water running or something breaks, that's a GL, general liability claim. So I'm only speaking here to errors and omissions. Your policy form, and there may be one or two companies out there that are hybrids that I don't know about, but they're not big in the home inspection industry, I can tell you that. Your policy is a claims-made policy form. What that means is that policy will respond to claims first made and reported to you during that policy period. So it doesn't, when the inspection happened relates to the retroactive date on the policy. So if you don't notify the carrier when you get notice, so in Neil's example, in 2019, you get an email from your client or you get a lawyer letter or something saying, we think you made a mistake here and there's a claim. And then you don't hear you respond and you don't hear anything from them. And so you figure it's gone. And then when you renew your policy the next year, that person comes back and they file a lawsuit, because in New Jersey, they have 4 years to sue you. That's the statute of limitations for claims against home inspectors in New Jersey. So let's say you forget about it, it comes back, now your policy is already renewed, your carrier will deny coverage. They will decline coverage because you knew about it in the previous policy year and didn't report it. And then if the fail-safe is when your policy renews, you write on there and say, hey, this party came to me 6 months ago, not much came of it, but I'm putting you on notice. That would at least help you to get coverage. But if those two things are missing, your carrier is going to deny coverage. And a lot of inspectors, unfortunately, and this was really true in my private practice, many inspectors kept coming to me and saying, my carrier denied coverage, can you represent me out of pocket? And it was usually they didn't give notice during the policy year because they didn't want to get banged on their premium charges for something that might be nothing, or they just, they didn't want to turn it in for fear that it would cost them money, or that the insurance company would just roll over and pay the claim. And that's a huge problem. Now with our company, we got rid of all that. You can tell us every little thing that comes down the pike, and we only count it as an incident. And an incident doesn't count for purposes of your premium at our company. So let's say you get that email from the client you would let me know, hey, I got this contact from the client, and we would mark your file as an incident. And that would protect you so that if these people went away and you didn't hear from them and your policy renewed, and now they file a lawsuit, well, you already gave us notice. We don't hold that against you. Just because you tell us of an incident, that doesn't go on your loss run at the end of the year or affect your premium dollar whatsoever, just because something might be out there. Now, in addition to that, we provide pre-claim assistance. So we try to resolve the claim for you, either with a letter or if it's something you want to pay on, an amount up to your deductible. If we do that with you and settle the claim in our company, it's still just an incident. It's not a claim. We only count things as claims when you've been sued or a demand for arbitration is filed and we have to hire an attorney right away for you, or if we have to pay money above your deductible to resolve a claim or a judgment. If those things don't happen, but we help you resolve it, let's say you have a $2,500 deductible and you decide you want to pay these people $2,000, we'll prepare the release, we'll do all your responses and everything, but it's still not a claim in our company. Because it was the worst conversation I'd ever have with somebody coming to me and saying, but for me giving notice during the actual policy period when I found out about it, I would have coverage. And now they're facing tens of thousands of dollars in attorney's fees on a claim that they're going to win anyway. And that was the worst conversation I ever had to have as a lawyer to a client. But that's what happens. And so we wanted to eliminate, the idea that you're going to be penalized at all for telling us about something when we don't ever have to write a check. In that situation, we just want to help you get rid of it or respond to the client in a way that tells them they're never going to get a dime. But that was something that, when we formed this company, that was a primary issue that we had to resolve. And so in our world, you would tell us about that claim and you might say, hey, Joe, I don't want you guys to contact them yet. Let's see if it goes away. And then, it goes away, but they come back the next year. Well, we're going to cover you on that claim. Now, it might become a claim then when they come back if it's a lawsuit. But unless we have to write a check or hire a lawyer for you, that's not a claim to us. And we just want to make that thing go away. It's better for everybody. So I can only speak to how we handle that situation. But definitely if it's something where you didn't provide us notice and you didn't put it on your application on the next policy period, we would have to deny coverage. And so that's why we made it easy so you don't have to worry about being penalized. Because the other thing is we can't settle a claim without your written consent. So, there's no way you can go wrong by letting us know of every incident that comes down the pike. And if we can help you get rid of it, we will before it becomes a claim. But then at least it doesn't show up on your policy when you go to renew. Because you're in a state where you have to have insurance. So, anything that would jeopardize your ability to afford that insurance or to get that insurance, is a problem for you. And we recognize that, but again, I can't speak to what other people do.
One question, because one thing you had just said, you used the word 4 years. So the question is, clarify how long someone has to sue, 4 or 5 years from the inspection date or form of discovery?
Well, the statute in New Jersey doesn't speak to the discovery part of that. And so in New Jersey, it's 4 years, and it could reasonably be 4 years from the date the client knew or should have known that they had a claim against you. Because New Jersey has what we call the discovery rule, and you're not going to find that in any of these statutes. But it's a judicial method that judges act based on what's supposed to be equity. And it arises from, the classic case they used to tell us in law school would be a surgeon, performs an operation, and in the course of the operation, they leave a sponge in the patient. And you have 2 years to sue somebody for medical negligence, but you don't know for 6 months that that person committed negligence. So as a matter of equity, the statute wouldn't then start running until 2 years after you reasonably knew or discovered that you had a medical problem related to that surgery. So unfortunately, discovery rules not just apply to medical malpractice or any kind of personal injury cases, but it's applied across the board in New Jersey. And so what that means is if somebody really couldn't reasonably know that they had a claim against you for, say, 2 years after your inspection, that 4-year clock won't start running until 2 years after your inspection, which in practice makes it a 6-year statute. So that's a huge problem. Now, Dave and I, when we wrote our inspection agreements, have a clause in there that limits the ability of somebody to sue you to 1 year from the date of the delivery of the report or date of the inspection, regardless of when you first discover the claim. I would be the one who had to go to court and argue that many, many times in New Jersey, and we had a very high success rate. But understand that whether that clause is going to be enforced depends on the judge you're in front of. So you can amend the statute of limitations by contract in New Jersey, but it's going to depend on the judge. And I did have a couple occasions where a judge refused to enforce it in particular cases. One I had that was really just horrible result was one where my inspector client had not sent the contract to the person who became the plaintiff, their client. They didn't send it to him within 24 hours or 1 business day of the scheduling of the inspection. And so the judge threw out the whole contract, including the 1-year limitation, which would have got the case thrown out of court. So, anything contractual, you have to also remember that every other aspect of your contract better be, in line with New Jersey law for you to enforce those clauses. But if there's nothing in your contract and it's 4 years, and it could be reasonably 4 years from the date that your client discovers you have a problem. And Dave and I always use this example. We laugh about it, but he once got a letter, from his old inspection company. And actually, it wasn't even him. It was his franchisee that did the inspection, but it was a 25-year-old claim. And a lawyer wrote him a letter and said, hey, my clients just had a home inspection. They're selling the house. And for the first time discovered they had a stucco defect. And, you didn't put that in your inspection report 25 years ago. Now, I happen to know the lawyer, and it was pretty easy to explain to him that, number one, it wasn't Dave in the first place, but more important, we're not going to honor a claim 25 years old. You have to take us to court. But yeah, I mean, conceivably, could it be 6 or 8 years? Yeah, that could happen. So it's very onerous. Now, that's not something that the advisory committee has any control over whatsoever. That has to come from the legislature. And any change to that, because that provision's not in these regulations, that provision is in the Licensing Act. And so that would have to be an act by the legislature to amend that or change that. So I fully implore you, if you have the opportunity or who your local government representative is, that'd be something I'd really want changed if I was the home inspector in New Jersey, because that is onerous and that is a much longer period of time than a lot of states. You can go right over the bridge to Pennsylvania and it's 1 year. And in fact, when they redid the law there, I actually got to work on it a little bit with some of the folks on the Pennsylvania Home Inspector Committee, and we made sure to eliminate the possibility of the discovery rule applying in the statute, so that it now will say 1 year from date of the delivery of the report, regardless of when you discover you might have a claim. So, it's unfair, really patently unfair to New Jersey inspectors to have to deal with a 4-year statute of limitations, especially in the area you're in, because I mean, the weather alone on a year-to-year basis can significantly change the condition of the property. And these people can wait for 4 years and sue you, and the property has changed dramatically in those 4 years. And you've got to go try to defend yourself on something you did 4 years ago for 3 hours. So yeah, it's very onerous, but that is the state of the law in New Jersey. Was that all the question, Neil?
At the moment, yes. But
Okay.
just to bring up one other at 7:48, you just tell me when you want to conclude tonight, and then we'll continue on tomorrow night.
Sounds good. I think it looks like we have a couple discrete things we can do here right now, and then we can wrap it up and finish up tomorrow night. And so the insurance requirement's an easy one, and we've talked a little bit about insurance tonight. Again, the change is just from licensed inspectors to licensees, nothing more.
Sounds good.
But can you guys hear me?
I'm not,
That's better.
yeah, I'm not hearing anybody say that they can't, so we're good. Can somebody text me that they can hear Joe? Well, they're asking questions, so they must be able to hear you. Yeah.
Yeah, now I'm getting a whole bunch of interference in my headset.
Okay, we're doing good. I'm gonna, okay.
Can you hear me?
Yes.
Okay, good. I just disconnected my headset. As long as you can hear me, we'll just keep going. So this is the insurance requirement. Essentially, in order to keep your insurance license, you have to carry a minimum $500,000 of errors and omissions insurance. So not just GL, you have to have a $500,000 in errors and omissions. And you have to file proof of the policy with the committee. It has to have cancellation or non-renewal should not be effective unless and until the committee has received 10 days written notice of intention to cancel or non-renewal. So I know how we handle that at our company, that we would then submit notice to the board if we're going to cancel a policy for non-payment, for example. And we have to do that within 10 days prior to discontinuation of your policy. But you have to carry a $500,000 in E&O. You know, really in terms of how much E&O you should carry, kind of depends on where you're working. You know, if you're doing a lot of $1 million or $2 million homes, you might consider carrying at least $1 million in E&O. But you, at the bare minimum, you have to have $500,000 of E&O coverage available to you. And I can assure you, you know, that becomes a problem if you can't produce evidence of the insurance certificate upon request from the board. A lot of times, no matter what the complaint is, if somebody files a complaint against you, it used to be that the board would, as a matter of course, just ask you immediately for proof of your education status in terms of your continuing ed and a copy of your insurance certificate and the signed contract that you used for that inspection. You have to carry an identification card issued by the committee. The identification card shall contain your name, photograph, license number, and signature. Identification cards are not transferable for obvious reasons. That's why they license you individually. You can use a duplicate and of course pay a fee because everything comes with a fee. This section was completely removed from the statute in this go around. About the 2-year license and this renewal provision was all extracted from the regulations, including this section here. About the renewal process because they've changed all that, and I think that goes into more detail here. But essentially, that these are the new provisions for the licensing and the renewal procedures. So I would recommend to you first. I'm sure Dave would agree to reproduce the slides for anybody who's here and would like to have them. But these are basically the changes that were made and the time period, and if in addition, it's still a 2-year from last expiration date, but you have to submit for renewal prior to the date of expiration, and you can still go on inactive status, but you cannot engage in the practice of home inspecting or hold yourself out as eligible to engage in the practice of home inspecting in New Jersey until your license is renewed to active status. What does that mean? Well, for example, if you're gone inactive, you need to shut off the website because that's an advertisement that you're there and you can engage in the practice of home inspecting. That's what they mean by holding yourself out as somebody who's eligible to do it. You can't have any advertising out there that you can control. I mean, obviously, if you left brochures somewhere, nobody expects you to go pull brochures, but certainly, you know, you should have your website turned off so that you're not out there purporting to hold yourself out as a home inspector. And again, it's 2 years from the last expiration date. If a licensee does not renew the license prior to the expiration date, you may renew the license within 30 days of expiration by submitting a renewal application and the fee along with a late fee. So basically, you have a 30-day grace period there. And again, your license will remain valid and you will not deem to be practicing without a license if you exercise that 30-day grace period. And really, it's there to try to look. I mean, occasionally from time to time, something happens and something gets missed. And so they didn't want to make it onerous on anybody anymore. And so you have a little bit extra time here to deal with the renewal. But then your license can be suspended immediately if you don't file the renewal within 30 days of the expiration. And that can be an administrative suspension where they're just going to suspend you and send you notice. And again, you're responsible for knowing when you're suspended or when you're not. And this part F, a licensee who continues to engage in the practice of home inspecting with a suspended license shall be deemed to be engaging in unauthorized practice of home inspecting and shall be subject to action. So again, if you're suspended and you're found to be continuing to work, you will have a problem. You also need to check, depending on who your insurance carrier is, if your license is suspended, you may not also be covered by your policy. So I think that's probably a good place to wrap up here for tonight, unless there's any additional questions, and then we can pick up with this and some of the other substantive provisions tomorrow. And obviously, if you're going to be here tomorrow night and you forgot a question tonight and want to submit it tomorrow, I'm sure Neil will entertain your question and we can deal with it tomorrow.
Sounds good. I do thank you, Joe, for helping us tonight. Wish you and all the other attendees, home inspectors, we do thank you for attending tonight's meeting. Look forward to seeing you tomorrow night. And everybody have a great evening.
Thank you.
You got it.